Welcome to week 2 of Law and Bioethics, in which we will discuss the modern family and the laws surrounding genetic selection. This week, we're going to look at 3 major legal questions. First, who should have access to alternative reproductive technologies? And who should have to provide such services? Second, what services and technologies should be available to the public? And third, how should the law handle individuals who take part in ART and who are born through ART? Benitez versus North Coast Women's Care Medical Group is a 2008 case that is assigned reading for next week, but you may want to take a look at it earlier. This case involved a woman, Guadalupe Benitez, in California, who had sought fertility treatment with her lesbian partner at a clinic run by 2 Christian physicians who refused to offer IVF services to unmarried couples. And it's worth noting at the time that gay marriage was not legal in California. So the questions the courts had to face in balancing the rights of individuals, and particularly gay and lesbian individuals, not to be discriminated against the religious rights of the doctors, included, should physicians be required to offer artificial insemination specifically to lesbian couples? Should physicians be required to offer artificial insemination treatment to unmarried couples? And should physicians be required to offer artificial insemination treatment to unmarried women? And even though there's substantial overlap, these are really 3 different questions. Rather than stake out a position in advance, what I'd like to do is review the arguments both in favor and against Benitez's claim as they were advanced in court. First, Ms. Benitez argued that the service might not be available otherwise if all clinics were not required to provide it. Secondly, that an underlying sense of justice requires that all people have equal access to health care. Third, that because doctors belong to a guild, they don't operate in a market, for example, like barbers, they have special obligations. When I say a guild, it means that the government regulates the number of doctors who can practice, their access to training, their prices, and therefore they're a scarce commodity, and being such, they have extra burdens to serve the public. Fourth, there's a burden when you don't know whether or not you'll be served in a public place, whether it's a florist or a Woolworth counter or an IVF clinic, and that people should be able to expect that when they walk in the door of a clinic, they'll be served. Fifth, that denying gays and lesbians such services brands them with a badge of inferiority, to use the language of the court. And finally, that courts in general should not tolerate pernicious conduct, but should use the law to remake society for the better. The arguments against Benitez's claim include that physicians also have religious freedom, and particularly for an elective procedure, you don't want to drive Christian practitioners out of the business of offering IVF. Secondly, that there's something intimate and distinctive about the physician-patient relationship that makes it different from offering many services. So even if you believe that florists and bakers should have to treat gay and lesbian couples the same way as straight couples, you might feel differently about the intimate nature of the physician-patient relationship. And finally, there's a utilitarian concern. It is possible that if you drive Christian doctors from offering fertility treatments out of the field, the result will be there will be fewer such clinics overall, and therefore not only will straight couples have less access, but because there will be longer lines in other clinics, lesbian couples will have less access too, and in some sense a lowering tide will lower all ships. That means you need to ask yourself the question about whether the law should prioritize access, ensuring that everyone has the most access to care, or should prioritize equity, ensuring that all people have equal access to care. In 2008, the California Supreme Court ruled unanimously in favor of Ms. Benitez. However, it's worth noting this is not the law in most states. The Affordable Care Act, for example, does not apply. While the law prohibits discrimination on the basis of sex, including sexual orientation and gender identity, from any program or facility that receives federal funding, private facilities that exclusively provide reproductive services are excluded from federal funding and therefore the law's protections. At present, 15 states require insurers to cover fertility treatments. However, 13 of them define infertility in a way that excludes gays and lesbians, because they define fertility or infertility as the inability to produce children through heterosexual sex. 2 states, New York and California, have a broader definition. So questions you might ask yourself are, should Medicaid or public services cover IVF? Should private insurers be required to do so? And if so, what definition of infertility should apply? For example, should there be an age limit? Or should women of advanced age be allowed to use IVF, and should it be covered by Medicaid or Medicare even, or private insurance? And here are a couple of prominent examples. A woman in India gave birth at 72 in 2016. A Spanish woman gave birth to twins at 66, and shortly thereafter died of ovarian cancer. By comparison, the oldest natural birth without artificial technologies was that of Dawn Brooke in Guernsey, who at the age of 59 gave birth in 1997. I am not an obstetrician, but it's worth noting there is limited data on pregnancy over 50. There is clearly some increased risk to both mother and baby. Some of the increased risk to the fetus includes risk of chromosomal abnormalities, such as Down syndrome, but it's worth noting that mothers in nearly all states can be screened for and then terminate fetuses with chromosomal defects, but also that children with Down syndrome can live long and meaningful lives. There is no legal limit in the United States on how old a woman can be when she chooses IVF. However, some insurers and medical plans refuse to cover women over a certain age. More importantly, the enforcement mechanism through private clinics is to limit availability to women over certain ages, often 50 or 52 here in New York City. It's worth noting this is rarely a limitation imposed because of risk to the fetus or risk to the mother, and more because of sociological ideas by the providers about how too old is to be a mother. So you should ask yourself, should IVF be available to women at age 60? Before you answer that question, you might look at some of these celebrity men who had children at very advanced ages with much younger women. Or at the extremes, Les Khali, who at the age of 92 fathered a child with his 38-year-old wife, and Ramjit Raghav, who at 96 fathered a child with his 52-year-old wife. I mention this because if you are 51 years old as a woman and you come to the clinic with a 19-year-old husband, they may deny you services, but if you're 49 years old and you come with a 90-year-old husband, they may offer you services because of sociological ideas about men and women that should strike some of us as problematic. Often these ideas are advanced under the standard of the best interest of the child, and the argument that older parenting, particularly parents who may die before the children grow up, are not in the best interest of children. That may be, but I do want to draw a comparison to the case of Brianna Smazlit, who is a Canadian woman who became pregnant through IVF while having a diagnosis of terminal cancer, and her husband died shortly thereafter, and the public reaction was much more positive to her choice than it might have been for an older woman, even one with a longer life expectancy. And finally, it's worth noting that the idea that our parents will live until we are adults or into old age is very much a modern concept. So, for example, in the 19th century in Great Britain, even factoring out infant mortality, life expectancy was roughly 15 years shorter than today. For those of you who are fans of British novels like Jane Austen's Pride and Prejudice, it's worth noting that the only reason the plots in these novels work is because the men in their 20s have inherited their fortunes because their fathers have all died by that time. You should all read Davis versus Davis, which is the first Tennessee case to grapple with the question of what to do with frozen embryos when couples can't decide what to do with them after divorce. It's worth noting that at the time of the case, there was no case law and no statute in Tennessee, and very little guidance in the country, so they looked to experts. Law review articles, bioethicists, people like me. So one question you might want to ask is, what is the role of experts in such cases? Do they have more wisdom than ordinary people? Second question you need to ask is, what is the status of the embryo? Is it property? Is it a person? Or does it exist someplace in between, as the Davis court finally decided? And then third, you need to figure out whether there should be a bright line rule that applies to all cases, determining whether the husband should get it, the wife should get it, it should be destroyed, it should be brought to term, or whether or not there should be a case-by-case approach, depending on the totality of the circumstances. There have been numerous cases like the Davis case since that time, the most famous one involving the actress Sofia Vergara and her religious Catholic ex-husband Nick Loeb. If you're assuming that there should be a case-by-case approach, you might ask questions like, it doesn't matter whether or not the woman can no longer produce biological children because of advanced age or because of a cancer diagnosis and radiation. Or for that matter, does it matter if the man is too old or has some reason cannot produce genetic children? Does it matter whether either of the partners already had children in the past? And should it be the subject to contract? Should couples through prenuptial agreements be able to decide what to do with such embryos? Or do embryos have enough personhood that you shouldn't be able to contract for them like property? By analogy, there are certain things you can't make contracts about because they have implications for public policy and the welfare of others. For example, if as part of your marital agreement, you decided that when you got divorced, the couple neither party would be required to pay child support, but whoever got custody would also pay for the kid, would clearly be a violation of public policy and no court would enforce it. You can't contract out of child support, in other words. A similar situation involves cases of sperm banking and the possibility of fatherhood after death. Originally, these cases occurred when living fathers would choose to set aside sperm, usually when they became ill and the risk of losing fertility during treatment. And cases the courts had dealt with in the past included patients who expected to lose fertility but died prematurely before they were able to use the sperm when the partner knew they wanted to use the sperm. And at the opposite extreme, cases where there was no evidence that the partner would have wanted to use the sperm. You want to think about whether evidence that somebody wanted to be a father is the same or different from evidence that they wanted to be a posthumous father, because someone might have wanted to be a father while they were alive, but would not want to have had a posthumous child. In one high-profile case, a 26-year-old male only child of a wealthy British family died in an automobile crash. He was unmarried, not in a relationship, and never expressed his wishes about having or not having children. His grandparents had California fertility expert David Smotrich harvest his sperm 3 days after his death and used it to fertilize a donor egg that was carried to term by a surrogate. The couple are now raising the grandson, born from this endeavor, and are reportedly, according to the media, very happy. Should the sperm retrieval have been permitted? Posthumous sperm retrieval first occurred in 1980. It is illegal in a number of countries. In Great Britain, the Human Fertilization and Embryology Act dictates that no person can extract another sperm without explicit written consent, even posthumously. Israeli guidelines allow such to occur only in the case of a spouse, but not a request from another family member. In the United States, in contrast, there is no regulation, but of course you have to convince a physician to do it. Without taking a stance, it's worth thinking about the ethical considerations on either side of this debate. In favor of allowing such retrieval, families are well situated to know the wishes of the deceased. The family has to live with the results, and often this may be their only opportunity to have a biological child or grandchild. And in general, the deceased have very little control over their bodies, at least in the Western world, so this approach dovetails with other rules. On the other hand, fatherhood has numerous legal and political implications, such as inheritance, and there's always the risk of bad faith by the family. There's the high potential for conflict if multiple family members are involved. And there, of course, is the risk of negative impact on an orphaned or unwanted child. In answering whether people should have a right to alternative reproductive technologies in IVF, you also have to ask who should pay for it. And these are pre-COVID prices, but this gives you a sense of the cost of IVF, which at its cheapest is going to run somewhere between $20,000 and $25,000, in addition to various different tests for screening the embryo in different ways. By comparison, surrogacy through an agency can cost anywhere from $60,000 to $240,000. And unfortunately, there's also a market in babies, and you can buy a baby for about $20,000 in Romania to, according to Al Jazeera a few years ago, as little as $5 for a girl in Malaysia. There's also a famous article you may want to read by Landis and Posner that makes an economic argument in favor of a market in newborns. I'm not endorsing that position, but it is a challenging and complex article that suggests that this will allow babies to be raised by the families that most want them and release resources so that people who are indigent can raise families of their own. You should ask yourself whether infertility is a medical condition requiring necessary treatment, or if it's an elective intervention analogous to cosmetic surgery, or somewhere in between. Deciding infertility is a medical condition requiring necessary treatment is not the end of the conversation, but the start. Which of the services described should be paid for by society? By whom? How many chances do you get at IVF? And does context matter? What if you already have a dozen healthy children? Probably the most important modern thinker in healthcare is Lester Thoreau, who is a business school dean in Boston. And he explained that the challenge of American healthcare is that Americans are both libertarian and egalitarian. What did he mean by that? He meant, on the one hand, if there is a procedure available that can be done, we don't feel comfortable telling a wealthy person like Jeff Bezos or Bill Gates that they can't pay for it out of pocket because we're libertarian in nature. However, we're also egalitarian in nature, and once we allow someone to pay for it, then we feel obliged to pay for everybody else's or require insurance to do so that all have equal access. And a rising tide, so to speak, raises all costs. This argument has been applied to reproductive technologies, where we don't feel comfortable telling some people they can't pay for them out of pocket, and then eventually we feel obliged to require insurers or the government to pay for them for others so all have equal access. It is worth noting that historically, issues relating to pre-implantation genetic screening and diagnosis implicated abortion. That may change because we may be able to diagnose or even edit gametes before they're fused through oocyte selection, polar body biopsy, and other technologies before fertilization that will take these technologies out of the realm of the termination of embryos. That is a whole new set of ethical dilemmas. With PGS and PGD, you have to ask what forms of selection, if any, should be permitted. So the core endeavor is, should I be able to cull out embryos with specific genetic defects leading to specific fatal childhood illnesses like Tay-Sachs disease, which is a debilitating and fatal illness, usually that kills children before the age of 5. I will note as an aside that screening and culling are not the same, because you might screen for such illnesses but choose not to terminate your pregnancy. Although most individuals do, you might choose simply to want to prepare for such a child in advance. It is also worth noting that parents of children with diseases like Tay-Sachs can find the experience very powerful, and their children can lead meaningful lives. So, for example, Emily Rapp wrote a powerful book about raising a baby with Tay-Sachs. Ronan, The Still Point of the Turning World, which I highly recommend. Laura Rothenberg, my former student, wrote a memoir of her experiences with cystic fibrosis and came to my class and was asked whether or not she should have been born, and said that she had a fulfilling life, but she could not answer the larger existential question. And Gillian Doherty's father has written a powerful memoir about raising a child with Down syndrome. Again, a testament to the joy and meaning that one can have in a life, even with conditions that one might choose to use PGS or PGD to remove. Assuming a continuum, you then might want to ask whether you could use these technologies to cull for non-fatal conditions, like mental illness, like BRCA genes that increase the risk of breast cancer, disease that increase the risk of chronic illnesses, like diabetes or heart disease. It's important to note the long-term epigenetic implications of this are unclear, meaning we don't know whether removing genes for some purposes or culling fetuses with one condition will have societal implications for other genetic phenomena. For example, what if, as data suggests, genes that increase the risk of bipolar disorder in some individuals also increase the risk of creativity in their collateral relatives? So the long-term social implications are unclear as well. And then much further down a continuum, a practice I want to emphasize I am not endorsing, but just raising as a possibility, is what if I want a straight or cisgendered baby? Some genetic linkages have been identified, and you may be able to shift the odds of having a straight or cisgendered baby, even if you can't guarantee that outcome. Should we let you do that? What do you do with a family that says, we have nothing against gays and lesbians or transgender individuals, but we understand that having a straight cisgendered child will make that child's life easier? Change the world if you want us to have a baby where we don't engage in such practices and change. And it's worth noting that Maria New, who was a physician at Cornell and later at Mount Sinai, during her work on congenital adrenal hyperplasia, was, according to her papers, able to probably reduce the likelihood of having lesbian offspring. Whether or not this should be offered to couples is a very different question than whether it's technologically possible. And are there extremes where even if we generally don't accept this, we might say because of the social context, for example, if you have a child in a nation where homosexuality remains illegal, where you wouldn't want to subject your child to the suffering it might entail growing up gay. Social context is also implicated in gender selection. There is a massive shortage of women and girls. There's a gender gap in a number of Asian countries due to abortion and likely infanticide. So does it matter whether you're choosing to engage in gender selection in a nation like India, where such a gap occurs, or a nation like Sweden, where it doesn't? Does it matter if you already have 10 boys and you want to engage in gender balancing for your family? In a famous article in The Guardian a number of years ago, Philip Ball asked, designer babies, are they an ethical horror waiting to happen? And he outlined all the possible changes that technologies could lead to, and CRISPR, I will add, only makes this more likely. Factors like increased IQ, increased perfect pitch, taller, thinner children, blonde-haired, blue-eyed children, take your pick of different quote-unquote enhancements, though it's not clear all of these traits are actually better, so to speak. The question I want you to think about philosophically is, do designer babies increase or decrease equity? And the answer to that is not entirely clear, because we already live in a world with substantial inequity. If we lived in a world with high levels of equity, there would be a very likely risk this would lead to decreased equity. But rich people already hire SAT tutors for their kids, tennis coaches. They engage in a sort of mating through selective dating to find people who are smarter, prettier, more athletic, and the like. So maybe, as a counter-argument to the popular belief, if we offered genetic screening to everyone free of cost, we would actually result in more equity. This is particularly true with advances in CRISPR. If CRISPR, which could be a low-cost technology, were offered to everybody in the long run and were made safe, they could choose the traits they would want their children to have, and they wouldn't need to hire SAT tutors or tennis coaches. I'm not endorsing that view or rejecting that view. I'm simply raising it as something to think about. In one of the sample cases available in the resource section, a case similar to a real case from 2008 is discussed. This was the case of Paula Garfield and Tom Lickey, a deaf British couple with a deaf child who petitioned the Human Fertilization and Embryology Authority in Great Britain to be permitted to use PGD to select for a second child who would also be deaf. If you were on the FHEA, would you permit them to intentionally cull hearing embryos to have a deaf child? And if so, how is this different from deafening the child either in utero through surgery or at the time of birth? It is worth noting that the British Fertility Authority said no, but they had another daughter the biological way, the old-fashioned way, and she turned out to be deaf, and they are now a very happy couple. There clearly is a meaningful deaf culture and a meaningful deaf community. Is there a floor to the kind of disability or other ability you would allow couples to choose for in this process? For example, would you allow them to choose blindness or chondroplasia? Or what do you do with the prospective parent who says they want to have a disabled child? For example, the hearing parents, and I've encountered cases like this, who want a deaf child because they've been fascinated by deaf culture. We earlier discussed the question of whether or not embryos have personhood, whether they're property or people or something in between. The same could be applied to gametes. So the National Organ Transplant Act of 1984, which banned organ trafficking, specifically included sperm and eggs. The American Society of Reproductive Medicine has guidelines on financial compensation for egg donors, and it limits them to $5,000 with justification, or the suggestion that $10,000 and above is never appropriate. You should ask yourself, if they're sellable at all, why does it make sense to impose limits? Why are we simply not viewing this as a restriction on the rights of women and prospective donors to get the most out of what they're offering? The reality is those guidelines are usually ignored in practice, and donors can make up to $50,000 per cycle. There are significant questions, by the way, regarding informed consent in this process, because there are risks to donors, from weight gain and headaches to mood swings to OHS. The long-term consequences remain unclear. Does paying too much, you might ask, really coerce donors, or does it just compensate fairly? I leave that as an open-ended question. I'm occasionally asked about the health risks of IVF, which is a subject that has been written about extensively. There is small very small health risks for babies conceived via IVF, but broader health implications are unclear. Maybe some risk of hypertension, some insulin resistance. Um, this is probably important for the informed consent process on a population level, but not clear on an individual level whether these are significant factors weighed against other social factors in the producing of offspring. In other words, it might help a couple decide whether to use IVF versus natural conception, but there's no indication that it rises to the level of risk where policy implications might be implicated. The law also needs to grapple with the question of how many embryos can be transferred at once. You may remember the negative reaction to the octomom pictured on the bottom right in this slide, Natalie Suleiman, who had a large number of children through IVF. But that contrasts significantly from the public reaction, extraordinarily positive, to the Dion quintuplets in Canada, born in 1934, who were followed by the public very intensely for many years, and became a source of inspiration and joy for many people. The difference between reactions to natural and quote-unquote artificial high-order multiple births is striking. For example, the doctor involved in the Suleiman case, Michael Kamavara, had his medical license revoked by the state medical board in California in 2011. Regulation varies significantly by country. For example, in Canada, 21% of pregnancies achieved via IVF resulted in multiple pregnancies. In Canada, the IVF guidelines permit transfer of 4 to 5 embryos in women over 40. I mention this because you want to think about whether or not we should have a national standard or an international standard for various aspects of reproductive health. Here below are the American Society of Reproductive Medicine's guidelines. They are fairly technical and precise. They are more restrictive than a number of other nations. And for comparative purposes, here are the even more restrictive guidelines in Great Britain. One should ask yourself why there should be an ethical or legal standard that is different in Great Britain than in the United States for embryo transfer. I will mention briefly the subject of human cloning, because I think the human cloning debate is a testament to the dysfunction of our government. Congress has addressed the issue of human cloning multiple times in the last 20 years, but has not been able to agree on whether or not to ban therapeutic cloning or only reproductive cloning, and there is no federal law on the subject. Though a number of states, including Connecticut and New Jersey, but not New York, ban reproductive cloning, and a number of other states ban public funding of cloning. In some ways, this is not a pressing issue because there's very little data that large numbers of people want to be cloned. That being said, it does raise both ethical and legal issues relating to the health of the clone, the status of the clone, and whether clones will have biological obligations to their progenitors. We'll talk later in the semester about whether people have any obligation to their siblings or other relatives donating tissue and organs, but these concerns are particularly compounded by the issue of being a clone. And then there's simply the logistical questions. Are you the father of your clone? Are you the sibling of your clone? What impacts does cloning have on factors like inheritance? It's not clear what the right answer is, but it's very clear that if we are going to have clones ever, we do need to have answers to these questions to maintain stability in the law and the transactions relating to property. When I teach in person, I always ask my students how many of you would like to be cloned. No one ever raises their hand. And yet Congress spent a majority of its time dealing with ART since 1999, dealing with the issue of reproductive cloning. I mentioned the issue of whether or not there should be national standards, but we also want to ask whether the standards should be different, not just at an international level, but between states. And surrogacy raises this issue particularly. You may be familiar with the case of Mary Beth Whitehead and baby M. If not, I will briefly summarize it for those who did not grow up in New York during the 1980s. In 1984, a New Jersey woman named Mary Beth Whitehead entered a newspaper ad placed by William and Elizabeth Stern. She agreed to be artificially inseminated by Mr. Stern's sperm through traditional not gestational surrogacy and gave birth to a baby, now known as Melissa Stern, and she's very public about it, but at the time known as Baby M, in which she would assert no parental rights. In return, she received $10,000 for expenses. When the baby was born, Whitehead refused to surrender to the Sterns, and they sued to enforce the contract. No New Jersey law on this subject at the time, similar, for example, to the Davis case, where there was no law at the time in Tennessee, although the issue was different. She asked herself, who should win this case? The New Jersey Supreme Court ruled that surrogacy was against public policy and treated it like an ordinary parenting case. William Stern received custody as a biological father. Whitehead received visiting rights as a biological mother. When Melissa Stern turned 18, it is very clear that she sided with the Sterns, and at least at one point was not in touch or in communication with Mary Beth Whitehead. The Stern case drew significant public attention to the issue of surrogacy, and state laws evolved quickly thereafter. Unfortunately, they evolved in different directions. While there has been a shift toward recognizing surrogacy legally, you can see that there is still a significant patchwork at the state level. This is a good point to step back and describe the concept of the mailbox rule and the stoplight rule, because you want to ask yourself whether it's important to have laws that are all the same or whether it's more important to have laws that get the answer right. And that may depend on the circumstances. So, for example, it does not matter whether we all go on the red or go on the green, but it does matter that some of us go on the green and others of us go on the red, because that will lead to chaos. So with traffic lights, a rule of uniformity is most important. In contract law, there's something known as the mailbox rule. This governs whether or not when you put a letter in a mailbox, your contract is complete, or when the contract is received, it becomes complete. And this, in addition to being important that we all do it the same way, which way we do it may have significant implications for business and commerce. I mention all that because you want to ask yourself whether surrogacy is primarily the kind of situation where it's more important that we all do it the same way, or it's the kind of situation where it's more important that we all get the right answer. This slide gives you a sense, as of 2018, of how different states would have treated the Stearns and Mary Beth Whitehead differently. And the range of responses is enormous. There are some states where one would be the legal parent, some states where the other would be the legal parent, some states where they would both risk imprisonment for engaging in surrogacy contracts. I rarely give advice, but I am going to give advice against do-it-yourself ART. So this is a real case. William Murata of Kansas wanted to do a good deed. He answered an ad for a sperm donor placed by a lesbian couple, Jennifer Schreiner and Angela Bauer, and he gave them a cup with some sperm for free, and they all signed a contract absolving them of parental rights. A healthy baby was born. Everybody lived happily ever after. Only they didn't, because the Kansas Department of Child and Family Services sued Murata in 2012, saying he owed the state $6,000 because if a child had been receiving public benefits, and yet he was the father and owed support. Since they hadn't used a licensed fertility clinic or physician, Kansas said that he was still the legal father. You should ask yourself what you think about this case, but the key take-home message, because this is the law still in a number of states, is that do-it-yourself parenting through IVF, if you choose to absolve yourself of legal responsibility for the parent, may not be acceptable to the state. I mean, if you choose to absolve yourself of legal responsibility for the child, it may not be acceptable to the state. The alleged concern in these cases is that couples who actually did not engage in sperm donation will claim they do in order to avoid child support payments, or that other efforts will be made to avoid the kind of support that parents should offer and foist the burden on the state. I'm not saying that's occurred, but that at least is the rationale for these restrictions. Another area at the cutting edge of reproductive technology is that of three-parent babies. Three-parent babies are babies which, through IVF, use the sperm of a father and then a nucleus from a mother or a second parent and the cytoplasm of a cell from an egg from a third parent. The goal being to not expose the baby to the mitochondria of the parent giving the nucleus, to reduce the risk of a small number of rare diseases that are transmitted from mother to child through the mitochondrial diseases. So these three-parent babies are the product of one person's sperm, one person's cytoplasm and egg, and one person's nucleus from the egg. In essence, they have three biological parents. And the question arises whether or not this should be permitted. It does reduce the risk of disease, but creates legal complications. And then who are the legal parents of this child? Does, for example, the parent offering just the cytoplasm of the egg and mitochondria have any legal claim at all? This may seem like cutting-edge technology to us. That is a picture, by the way, of Alana Saarinen, who was the first woman in the United States born through this treatment. But no more shocking than Louise Joy Brown, who was the first person born as a quote-unquote test tube baby in 1978. In both cases, there were predictions that this would lead to legal chaos, and so far it has resulted in neither case. There is now a legal moratorium on such practices in the US, but that does not mean the practice will stop because there are countries where it is legal. For example, John Zhang was a physician who brought a couple to Mexico for the procedure in 2016. So I think one of the major legal questions to think about in the context, not just of human reproduction, but in a number of the areas we're going to look at, is that of medical tourism. And here we talk about reproductive tourism. The concern is that no matter what standards you impose in the United States, or whatever country you happen to be standing in, there will always be a more permissive country out there. And how do you regulate the access in foreign countries to practices that you don't want to occur? Or if they're going to occur in ways in foreign countries that are more problematic, should you permit them to some degree in the US to mitigate that harm? This is obviously not a live lecture, so I can't take your questions. However, I will set up a session to take questions sometime in the next week or so.